Good morning. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is June 26th, 2019. The time is 9:30 a.m. With us today are Commissioner Emily Lindley and our General Counsel, Mary Smith. I'm John Neerman, and Ms. Smith, I'll ask you to call the first item.
Item number 1 is the application by WPS1 LLC for new TPDES permit number WQ 0015679001 to authorize the disposal of treated domestic wastewater. The parties have been notified that the commissioners will not take oral argument but may ask question, and the presence of those who have signed in on this item will be noted for the record.
So, Commissioner Lindley, we have two requests on this for a hearing on this item, one from Mr. Cox and one from Ms. Owens. Mr. Cox resides near but not adjacent to the facility, and he raises really what, in my mind, amounted to general concerns about pollution without identifying really how they would affect him personally, and so I think we should deny his hearing request. I don't think he's established a affected person status.
I would agree.
And I do want to just offer an observation or opinion. As I understood the ED's position on this, it was Mr. Cox's lack of adjacency to the facility or the discharge route in itself that that made his hearing request deficient. I don't view it that way. I think that where his property is located could, in another case perhaps, create an affected person status if he had articulated personally justiciable issues. I just thought I'd point that out just for the record, for what it's worth. Yeah. And then as to Ms. Owens, she does reside adjacent to the proposed facility. And importantly, she identifies personal justiciable issues. You know, she articulates how she could be impacted specifically by odors from the facility or with respect to health issues. So I would grant her hearing request. She also raises the issue of regionalization, the state's regionalization policy. So I would refer her on those three issues: odor, health issues, and regionalization.
I would agree. I think all of that is appropriate, and I can make a motion if you're ready.
Sounds good. And concurrent ADR referral, and how long would you propose for that?
My motion would be for 120 days, since it's one party and a shorter list of issues.
Yeah, that makes sense.
Okay. With that, I move that we grant the hearing request of Sophie Owens, that we deny all remaining hearing requests, that we refer the matter to TCEQ's Alternative Dispute Resolution Program to run concurrently with the SOA preliminary hearing scheduling efforts, that we refer the application to SOA for a contested case hearing on the following issues. A, whether the proposed wastewater treatment facility will negatively impact human health. B, whether the proposed wastewater treatment facility will generate nuisance odors. And C, whether the commission should deny or alter the terms and conditions of the draft permit based on consideration of need under Texas Water Code 26.0282 and the general policy to promote regional or area-wide systems under Texas Water Code 26.081, and set the hearing date for 120 days from the date of the preliminary hearing until the proposal for decision is issued.
The motion has been made. I second it. All those in favor say aye.
Aye.
Aye. The motion carries.
Item number 2 is the consideration for adoption of the first submission of the draft 2018 Texas Integrated Report for Clean Water Act Sections 305B and 303D, the Spring Creek segment 1008. And the Executive Director's staff is here to present the item.
Good morning.
Good morning. Good morning, Chairman, Commissioner Lindley, General Counsel, Public Interest Counsel. For the record, I am Kyle Gerton with the Water Quality Planning Division in the Office of Water. With me are Andrew Sullivan and Lori Hamilton, also of the Water Quality Planning Division. and Michael Parr with the Environmental Law Division. We're here today to request your consideration to adopt the first submission of the draft 2018 integrated report and supporting documentation. This report will be submitted to the EPA for approval as required by the Federal Clean Water Act, Sections 305B and 303D. The integrated report summarizes the degree to which water bodies support the uses and criteria in the Texas Surface Water Quality Standards. The first submission of the draft 2018 integrated report includes the status of Spring Creek, segment 1008. The assessment resulted in the delisting of Spring Creek for dissolved oxygen. Revised site-specific dissolved oxygen criteria for Spring Creek were adopted in the 2018 Surface Water Quality Standards on February 7, 2018, and were approved by the United States Environmental Protection Agency on November 2, 2018. However, because Spring Creek site-specific dissolved oxygen criteria were not approved by EPA before the 2016 integrated report was completed, the TCEQ developed the first submission of the 2018 integrated report to submit to EPA, which only includes the assessment of Spring Creek. The remainder of the water bodies for the 2018 integrated report will be included as a second submission of the 2018 integrated report later this year. The Guidance Advisory Work Group met to discuss the methodology that was used to develop the integrated report. The first submission of the draft 2018 integrated report was released for public comment on March 22, 2019, and the public comment period ended on April 22, 2019. One comment letter was received. Staff prepared a response to the comment, which is included in your backup material. We respectfully request approval and the adoption of the first submission of the draft 2018 integrated report and your direction to submit to EPA. We also request permission to make additional non-substantive revisions if needed before submittal to EPA. Thank you for your consideration. We are available for questions.
Thanks. I think I've got a couple. Is this the first time that we've bifurcated submission of this report?
This is the first time, yes. We've done partial submissions before, but this is the first time that we bifurcated it.
And one of the reasons why we're moving ahead with the Spring Creek piece is because we have some pending applications that are just hanging out there until we're able to submit the report. Is that correct?
That is correct.
Okay. So if we were to wait and do it all in one package, we would just be leaving those applications hanging.
That is correct.
Okay. Thank you. Commissioner Lindley, any questions?
No, I appreciate your questions. I'm comfortable moving forward, but we hear from the others first.
Mr. McWhorter.
OPIC recommends adoption of the first submission of the draft 2018 Texas Integrated Report as presented by the Executive Director.
I agree. I think it's appropriate. We should move forward, and we'll entertain a motion.
Okay. I move that we adopt the first submission of the draft 2018 Texas Integrated Report for submittal to the United States Environmental Protection Agency as required by the Clean Water Act, Sections 305B and 303D, as recommended by the Executive Director.
The motion has been made. I second it. All those in favor say aye.
Aye.
The motion carries. Thank you.
Chairman, I'd like to make a clarification on item 1.
Sure.
I misspoke, and when I was discussing the setting of the hearing, I misspoke, and what I meant to say was that I want to set the duration for the hearing of 120 days, just for the record.
That's what I thought I heard.
Okay.
But maybe the
Well,
record,
to be extra clear.
the record
duration of
indicated that you
120
said
days.
something else.
Yes.
But
Sounds like I said a date instead of duration, so. I don't know if we need to do
I
anything
appreciate
further.
that. Do we need to do any?
No, I think we can note that in
Okay.
the order now.
Okay.
Thank you.
Thank you. Next item.
Item number 3 is consideration for adoption of the renewal with amendments of TPDES General Permit Number TXG 920000, and the Executive Director's staff is here to present the item. and the presence of those signed in who indicated that they don't wish to speak but are available for questions will be noted for the record.
Good morning.
Good morning, Chairman, Commissioner, General Counsel, Public Interest Counsel. My name is Charles Schneider. I'm the team leader of the Land Application Team in the Water Quality Division. With me today is Michael Parr with the Environmental Law Division and Joy Alabi, also with the Water Quality Division. The Executive Director requests that the Commission adopt the renewal with amendment of the Concentrated Animal Feeding Operation, or CAFO, General Permit Number TXG 920000, and the response to comments under 30 TAC Chapter 205. The general permit will provide authorization for discharge of manure, sludge, and wastewater into or adjacent to water in the state by CAFOs only during chronic or catastrophic rainfall or catastrophic conditions. The general permit provides coverage for both Texas Pollutant Discharge Elimination System and state-only CAFOs. The general permit specifies which facilities may be authorized under this general permit and which facilities must be authorized under an individual permit. Staff solicited input from stakeholders prior to proposal of this draft general permit. After incorporating the stakeholders' recommendations, the revised general permit was published for public comment on February 22nd, 2019 and February 23rd, 2019. The notice of availability of the draft general permit was published in 5 newspapers throughout the state of Texas and in the Texas Register. In addition, the Executive Director held a public meeting on March 25th, 2019 in Austin and accepted public comments. The comment period ended on March 25th, 2019. The Executive Director considered and responded to all comments in the response to comments and revised the draft general permit in response to comments. Overall, changes are proposed to the general permit to improve clarity and consistency and to conform with EPA electronic reporting requirements and to address comments received from stakeholders and agency staff. In conclusion, the Executive Director respectfully requests the adoption and issuance of the CAFO general permit in response to comments. We're available to answer any questions. Thank you.
And I have none. Commissioner Lindley?
I don't have any questions. I appreciate the work done on this one, and that goes to the Executive Director, staff, and then all the stakeholders that were involved as well. And it's always nice to see when they comment and that the ED is then responsive to those comments. So appreciate the work done on this.
Mr. McWhorter?
OPIC recommends approval and issuance of the renewal with amendment of the Texas Pollutant Discharge Elimination System State General Permit authorizing concentrated animal feeding operations and the response to comments as presented by the Executive Director.
And I agree. I think we ought to move forward on this.
I agree. With that, I move that we adopt the renewal with amendments of the Texas Pollutant Discharge Elimination System General Permit number TXG 920000.
And Commissioner Lindley, let me add to that. Maybe
Okay.
what I'll do is I'll read a motion here to include response to comments. I move that we adopt the renewal with amendments of the Texas Pollutant Discharge Elimination System General Permit Number TXG 920000 and the response to comments.
I second.
The
Or-
motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries.
And this takes us to the enforcement docket, which is items 4 through 24. I'll wait for everybody to get up. And the Executive Director's staff is here to present these matters. No one has signed in to address the commission on these items.
Good morning.
Good morning, Chairman, Commissioner, General Counsel, and Public Interest Counsel. For the record, my name is Brian Sinclair of the Enforcement Division, and with me today are Megan Hamilton, also of the Enforcement Division, and Charmaine Backens and Janice Hernandez of the Litigation Division, representing the Executive Director. Pending before you are items 4 through 24. The total assessed administrative penalties are $385,511, with $64,386 deferred, $62,751 applied towards supplemental environmental projects, and $258,374 to general revenue. We respectfully request approval of these items and are available to answer any questions that you may have.
I have none. Commissioner Lindley?
I don't have any questions either. Thank you.
Mr. McWhorter?
My office reviewed these items, and we recommend issuance of the proposed orders.
I agree, and I'll entertain a motion.
I agree. I move that we adopt items 4 through 24 as recommended today by the Executive Director.
The motion has been made. I second it. All those in favor say aye.
Aye.
The motion carries.
And now, item number 25 is the consideration of the monthly enforcement report. And again, the Executive Director's staff is here to present this item, and no one has signed in on the item.
All right, well, we're back. Good morning, Chairman, Commissioner, General Counsel, Public Interest Counsel. My name again is Brian Sinclair of the Enforcement Division, and with me is also Megan Hamilton of the Enforcement Division and Charmaine Backens and Janice Hernandez of the Litigation Division. We're here to present the monthly enforcement report for fiscal year 2019 through April. There were 859 effective administrative orders issued, and of those, 101 contained supplemental environmental projects. These orders assessed a total of $7,708,423 in penalties, with a payable amount of $4,732,599, $1,718,807 are paid towards supplemental environmental projects. 10,941 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 1,095 enforcement action referrals have been received. There are 1,575 pending administrative orders, with 131 cases that are on backlog. 206 cases are pending at the Attorney General's office for representation in district court, and 19 judgments have been issued. 2,053 cases are being tracked for compliance. We have included for review a summary of OCE investigative activities for fiscal years 2017, 2018, and 2019. We're available to answer any questions that you may have.
Thank you. I have none. Commissioner Lindley?
No questions.
Mr.
Thank you.
McWhorter?
I don't have questions either. Thank you.
Thanks for the report.
Items 26 through 31 are the quadrennial rule reviews for chapters 117, 222, 318, 327, 332, and 334 of Title 30 Texas Administrative Code. The Executive Director's staff is here to present the matters, and no one has signed in to address the Commission on these items.
Good morning.
Good morning. Good morning, Chairman Nerman, Commissioner Lindley, General Counsel, and Public Interest Counsel. For the record, my name is Patricia Duran from the General Law Division, and with me today is Anthony Tatu from the Environmental Law Division, representing the Executive Director. Pending before you are items 26 through 31, the adopted rule reviews of 30 TAC chapters 117, 222, 318, 327, 332, and 334. As required by Texas Government Code, Section 2001.039, Executive Director staff conducted rule reviews of these chapters to determine if the need for the rules within these chapters continue to exist. The proposed notice of the rule review of chapters 117, 222, 318, and 332 were published in the January 18, 2009 issue of the Texas Register with a 30-day comment period. The proposed notices of rule reviews of chapters 327 and 334 were published in the December 21, 2018 issue of the Texas Register, also with 30-day comment period for review. No comments were received during the public comment period for these reviews. Based on the reviews of these chapters, the Executive Director has determined that the reason for the rules continue to exist. Additionally, during the course of these reviews, the Executive Director determined that rule language in Section 332.3, subsection A, paragraph 2, and paragraph 3, subparagraph A, is obsolete and no longer needed because of its redundancy to other authorization requirements, and the rule language in 332.3, Subsection A, paragraph 3, subparagraph B is obsolete and no longer needed because it pertains to permit requirements for existing registered facilities when the composting permit requirements were promulgated in January 8th, 2004. The obsolete rule language will be addressed in a future rulemaking action. We respectfully recommend approval of the adoption of the rule reviews of 30 TAC Chapters 117, 222, 318, 327, 332, and 334. Additionally, if staff requests authorization to make non-substantive revisions necessary to comply with Texas Register requirements. Thank you. Project managers and attorneys are assigned to each of these reviews are here with us to answer any questions you may have.
Thank you. I have none. Commissioner Lindley?
I don't have any questions, and I'll just say that I think what I will propose that we maybe do is, to initiate a rulemaking to eliminate these obsolete sections. But I will say, when I was reading through this, I'm not an attorney, and so I didn't understand fully why we were still moving forward and keeping them in there, because if they're obsolete, that's, to me, the initial reading, the point of a quadrennial review is to delete it. I've dug a little deeper, and I understand there are reasons why we're moving forward the way we're moving, and so I appreciate that explanation. But I'm just wondering, and today is not the day, but maybe in the future, we need to have some sort of discussion about how quadrennial reviews are done, because I don't want this to be a cycle where in 4 years they're before us again. There's little obsolete sections, and because of rulemaking, didn't happen between now and then, and so it's still in front of us. I don't think that will happen. I do think the ED is moving forward on deleting or the obsolete things where they need to be deleted, but I don't want to see them again, because I think that kind of defeats the purpose. But I know there are reasons why today it's appropriate to move forward with just directing a rulemaking. So more of a comment than a question.
Yeah, and Commissioner, for what it's worth, the way I've understood it is it's helpful for the agency to move through our quadrennial reviews efficiently, and by adopting the reviews and readopting the rules in their entirety, we can move through it quickly. Now, you raise a very good point. What about, why are we readopting rules that are obsolete? And the way I've answered that is because you need to strike obsolete rules very carefully. You need to study how they may be attached to other parts of the regulation, and do it in a considered way. And I think there are perhaps some efficiencies to be gained too if we reopen the rule for other purposes.
Yes.
We just have those on a list
Yeah.
as something to address. So that's how I've made sense of it.
Yes,
But
that's where I landed eventually. It
Yeah,
just
my
took me a
initial
little while
reaction-
to get there. I'll just say that. So I appreciate all the work that goes into it, and look forward to continuing to see the work done on these.
Likewise, my reaction was the same as yours initially, but
Thank you.
thanks. Mr. McWhirter?
OPIC recommends adoption of these reviews and readoption of these chapters as presented by the Executive Director.
I agree, and I'm ready to entertain a motion.
Sounds good. I move that we adopt the rule revisions and readopt the rules in chapters 117, 222, 318, 327, 332, and 334 of Title 30 Texas Administrative Code without amendment, and that we direct the Executive Director to initiate a rulemaking to eliminate the obsolete sections identified by the Executive Director in 30 Texas Administrative Code, Chapter 332, before the next quadrennial rule reviews of that chapter.
The motion has been made. I second it. All those in favor say aye.
Aye.
The motion carries. Thank you.
Items 32 through 35 are for closed session, and the commission will not meet in closed session today.
The time is 9:54, and we are adjourned.